Make sure I understand every term, every calculation, every trigger. My colleagues think I'm overly cautious. Maybe I am, but I've seen what happens when you're not. The experience taught me about power, how it works, where it sits, when it shifts. Companies have structural power, resources, lawyers, time, but individuals have contractual power. If the words are clear, if the documentation exists, if you're willing to use it. The case file is still at Margaret's office, archived, closed, complete. I don't need to access it, but it's there if I ever do. Proof that I stood up, proof that I won, proof that contracts mean something. I'm 3 years into my new role now. Different projects, different colleagues, different challenges. The bonus dispute is distant history, relevant only when I review new contracts, or when someone asks about reading the fine print. Then I tell them, always read everything, especially the appendices. Those 11 pages changed everything for me. I scheduled a consultation with an employment lawyer. Found one through a professional network. Good reviews. Experience with contract disputes. The appointment was 3 days out. In the meantime, I worked normally. Attended meetings, completed analyses, responded to emails. My manager acted as if nothing had happened. Assigned projects, provided feedback, maintained his usual tone. I did the same. Professional, compliant, quiet. But I started documenting everything. I made copies of my contract, the original offer letter, the amendment, Appendix B. I pulled my performance data, revenue reports, client retention metrics, project completion records, every number that supported my case. I also searched my email for the HR conversation when I'd signed the amendment. Found it. The HR coordinator had written, "The new structure ties your bonus directly to measurable performance outcomes. Hit the targets in Appendix B and the calculation is automatic." Automatic, not discretionary. I saved everything to a personal drive, organised it chronologically. Then I waited for the lawyer appointment. The lawyer's name was Margaret Chen, mid-40s, sharp, direct. We met in her office in the CBD. I brought printed copies of everything. She reviewed the contract first, read it carefully, then read Appendix B. "This is interesting," she said. "What do you see?" "Conflicting provisions. The main clause says discretionary. The appendix creates a mandatory calculation. Both are part of the same contract." "Which one controls?" "That's the question. In contract law, when provisions conflict, courts apply rules of interpretation. Specific provisions typically override general ones. Later amendments typically override earlier terms." "Appendix B is specific and was added later," I said. "Exactly. The appendix was part of the amendment, correct?" "Yes, 18 months ago." "And the original contract just had general discretionary language?" "Yes." She made notes. "Did you rely on the appendix when you accepted the amendment?" "Yes. HR explained that my bonus would be calculated based on those metrics. I accepted a lower immediate raise because of the performance bonus structure." "Do you have that in writing?" I showed her the email from HR. She read it, nodded. "This strengthens your position. You have evidence that the company represented the bonus as tied to specific metrics. You relied on that representation. You performed accordingly." "What's my next step?" "Write a formal demand letter. Cite the contract provisions, reference the HR email, request the $47,000 bonus within 30 days. Be professional. Don't threaten. Just state your position clearly." "And if they refuse?" Then we consider legal action. You could file a breach of contract claim, or potentially a complaint with Fair Work if there are wage issues. How long would that take? Months, possibly a year. Depends on their response and whether it goes to hearing. Is it worth it? For $47,000? She looked at me directly. That depends. Do you value the principle? Are you prepared for the stress? Can you afford the legal fees if it goes badly? I thought about it. What are legal fees? If we settle quickly, a few thousand. If it goes to full litigation, could be 20 to 30,000. You might recover those if you win, but it's a risk. I thanked her, paid for the consultation, left her office, sat in a cafe, thought. $47,000 was significant, almost a third of my base salary. But litigation was risky, expensive, time-consuming. I decided to try the demand letter first, see how the company responded. Margaret drafted it for me. I reviewed it, approved it. She sent it on my behalf 2 days later. The letter was formal and detailed. It cited the contract language, referenced Appendix B, quoted the HR email. It calculated the bonus amount based on my performance metrics, and it requested payment within 30 days. It concluded, "We trust this matter can be resolved amicably without further action. However, Ms. Preston is prepared to pursue all available remedies if necessary." Professional, firm, clear. Margaret sent it to the company's legal department and HR, copied my manager. I received a read receipt the same day. Then silence. Days passed. My manager didn't mention the letter, didn't change his behaviour, acted as if I'd never challenged the bonus decision. I did the same, worked normally, stayed professional, documented everything. 1 week after the letter was sent, I received an email from HR. "Chloe, we've received correspondence from your legal representative regarding your performance bonus. We're reviewing the matter and will respond through appropriate channels." Appropriate channels? That meant they were taking it seriously. I replied briefly, "Thank you for confirming receipt." Then I waited. 2 weeks passed. No response from the company. I checked in with Margaret. "This is normal," she said. "They're probably consulting their own lawyers, reviewing the contract, deciding how to respond." Should I do anything? Keep working, keep documenting, stay professional, don't discuss this with colleagues. I followed her advice, but I noticed changes at work. Small things. My manager started CCing HR on emails about my assignments. Never did that before. He also started documenting our conversations in writing. Per our discussion today, you'll focus on the Q1 revenue analysis. Formal, careful. He was building a file. I did the same. Confirmed every instruction in writing, documented every deliverable, saved every email. If this was going to escalate, I wanted records. 3 weeks after the demand letter, Margaret called. I received a response from the company's lawyers. And? They're denying the claim. They argue the main contract clause controls. They say discretionary means they have no obligation to pay regardless of performance. What about Appendix B? They claim it's guidance, not a guarantee. They say the shall language is qualified by the discretionary clause in the main text. That's inconsistent with what HR told me. I know. I pointed that out. They say HR doesn't have authority to modify contract terms. What now? We can file a claim, or we can negotiate. Negotiate what? A settlement. Maybe they pay partial amount to avoid litigation. Maybe they pay nothing but you get a good reference. Depends what you want. I thought about my options. Full litigation would take months, cost thousands, create stress. But I'd met the performance triggers. I'd earned that bonus. What do you recommend? I asked. File the claim. It shows you're serious. Once it's filed, they'll likely want to settle to avoid discovery and potential publicity. How do I file? I draft the statement of claim. We file it with the appropriate court. They have to respond. Then we go through mediation, potentially trial. How long? 6 months minimum, could be longer. I hesitated. Margaret spoke again. Chloe, you have a strong case. The contract language is ambiguous. The HR email shows how the company interpreted it. Your performance is documented. Most companies settle these cases rather than risk a judgment. Okay, I said. File it. I'll need a retainer, $5,000 to start. I transferred the money that afternoon. The claim was filed 2 weeks later. Statement of claim. Preston versus company name, breach of contract, seeking $47,000 plus interest and legal costs. The company was served officially. They had 28 days to respond. I continued working. My manager's behaviour changed noticeably. He became more distant, more formal, stopped assigning me to high-profile projects, gave me routine analysis work instead. I documented it all. Every reassignment, every exclusion from meetings, every change in responsibility. If they were retaliating, I wanted proof. 4 weeks after the claim was filed, the company filed their defence. Margaret sent me a copy. They denied breach, argued discretionary language, claimed no obligation. They also filed a counterclaim. They alleged I'd been insubordinate, failed to follow management direction, created a hostile work environment by pursuing legal action. I read it carefully. It was aggressive, accusatory, completely unsupported by facts. I'd never been disciplined, never received a written warning, never had a negative review. Margaret called me. This is a pressure tactic. They're trying to intimidate you into dropping the claim. Will it work? Not if you're prepared to fight, but we need to respond formally, and we should document any workplace retaliation. I've been documenting everything. Good, send me your notes. I sent her my file. Every email reassignment, every meeting exclusion, every change in tone. She reviewed it. This supports a retaliation claim. If they're punishing you for exercising legal rights, that's prohibited. Should I file a separate claim? Not yet. Let's use it as leverage in the current case. The case moved to mediation, court-ordered, mandatory before trial, scheduled for 8 weeks out. In the meantime, work became increasingly uncomfortable. My manager avoided me, communicated only by email. Colleagues seemed uncertain how to act. I'd been told not to discuss the case, so I didn't. Just worked, stayed professional. But the isolation was obvious. I started updating my resume, looking at other opportunities, not because I wanted to leave, because I wanted options. The mediation was held at a neutral location, conference room, mediator, lawyers on both sides. My manager wasn't there, just the company's legal team and an HR executive. The mediator explained the process. We'll discuss positions, explore settlement options. Everything said here is confidential and without prejudice. The company's lawyer spoke first. Our position is clear. The contract gives management discretion. Miss Preston's claim has no merit. We're prepared to defend it fully. Margaret responded. The contract is ambiguous. Appendix B creates specific triggers. Miss Preston relied on HR's representation. She met every metric. The company is in breach. The mediator asked questions, reviewed the contract, read the HR email, examined my performance data. After 2 hours, he caucused with each side separately. He met with us first. The company is concerned about the cost of litigation and the potential for adverse publicity if this goes to trial. They're willing to discuss settlement. What are they offering? Margaret asked. $15,000, plus a mutual non-disparagement agreement. less than a third of what I was owed. "That's insulting," I said. Margaret nodded. "We'll reject that. Counter with $42,000 plus legal fees." The mediator went back to the other room, returned an hour later. "They'll go to $25,000. That's their final offer." I looked at Margaret. She shrugged. "It's your decision. That's about half. Saves you litigation risk and costs." I thought about it. $25,000 was real money, but I'd earned $47,000. "No," I said. "I want what I'm owed." The mediation ended without settlement. The case proceeded toward trial. Discovery began, document exchange, interrogatories. The company produced thousands of pages. I produced my performance records, emails, and documentation. Margaret found something interesting in their production. "Look at this," she said. It was an internal email from the CFO to my manager, dated 2 months before year end. "We need to reduce bonus payouts this year to improve margins. Use discretionary language to minimize payments. Target 60% reduction across the board." Target reduction. They'd planned to deny bonuses regardless of performance. "This is evidence of bad faith," Margaret said. "They weren't exercising genuine discretion. They had a predetermined plan to deny bonuses." Does that help our case? Significantly, it shows the decision wasn't based on individual performance assessment. It was a blanket cost-cutting measure disguised as discretion. We spoke an amended claim, added breach of good faith and fair dealing, cited the internal email as evidence. The company's response was swift. They requested a settlement conference, scheduled for 2 weeks later. This time the CFO attended, and your senior lawyer. The tone was different, more conciliatory, less aggressive. "We'd like to resolve this matter," the senior lawyer said. "What would Miss Preston accept?" Margaret takes our position. $47,000 as calculated under Appendix B, plus $8,000 in legal fees incurred to date. Total $55,000. The CFO winced. "That's substantial." "It's what's owed under the contract," Margaret said, "plus costs your company created by refusing a valid claim." They caucused privately, returned 30 minutes later. "We'll agree to $47,000, but no legal fees, and we need a full release and confidentiality agreement." Margaret looked at me. I calculated quickly. $47,000 was the bonus amount. I'd spent $8,000 on legal fees so far. Net would be $39,000, but it would end the case. "I'll accept $47,000 if they also provide a neutral reference and remove the counterclaim," I said. Margaret negotiated. They agreed. The settlement was drafted that afternoon. The settlement agreement was 7 pages, payment of $47,000 within 14 days, dismissal of all claims and counterclaims, mutual non-disparagement, confidentiality about settlement terms, neutral reference confirming employment dates and title only. I signed it. The company signed it. The case was dismissed. The payment arrived 11 days later, $47,000, exactly as specified. I paid Margaret her outstanding fees, kept the rest. At work, nothing changed immediately. My manager continued avoiding me. My projects remained routine. But I'd already started interviewing elsewhere. Found a role at a competitor, better title, better salary, better clarity about compensation structure. I gave notice 2 weeks after the settlement cleared. My manager seemed relieved. HR processed my exit professionally. The neutral reference was provided as agreed. I left on my last day without ceremony, just handed in my laptop and walked out. The new role started a month later. Different company culture, clearer communication, better defined expectations. I reviewed my new contract carefully before signing, asked questions about every ambiguous clause, made sure compensation terms were crystal clear. The company appreciated the diligence. "We value employees who read carefully," my new manager said. I appreciated that attitude. I think about that experience sometimes. The months of stress, the legal fees, the workplace tension. Whether it was worth it for $47,000, the answer changes depending on the day. Financially, I came out ahead, got the bonus I'd earned, moved to a better role. But the cost was high in other ways. The isolation, the retaliation, the uncertainty. Those weren't measured in dollars. I learned something important, though. Contracts matter. Every word, every clause, every appendix. If something is ambiguous, clarify it. If it contradicts, question it. Don't assume good faith. Don't trust verbal assurances. Get everything in writing. The settlement agreement is locked away. I can't discuss the terms publicly, can't badmouth the company, can't disclose the amount. That's fine. I have what I earned. That's what mattered. My former manager is still at the company. I see his name occasionally on LinkedIn. Same title, same company. I feel nothing about that. Our paths diverged. His choices were his own. Mine were mine. The CFO who sent that internal email about cutting bonuses left the company 6 months after my settlement. I heard through industry contacts it was performance-related. Ironic, but not my concern. I still have Appendix B, the 11-page document that specified my bonus calculation. I keep it as a reminder, not of the fight, but of the importance of reading carefully. Every contract is a promise. Some companies keep their promises. Others need reminding. My current company has a different bonus structure, simpler, clearer, no discretionary language, just if revenue exceeds X, bonus equals Y. Mathematical, transparent. I appreciate that. People ask sometimes if I regret suing my former employer, if it damaged my career. It didn't. My new company didn't care. They cared about my skills and experience, not about contract disputes. And the experience taught me to advocate for myself. That's valuable in any career. The settlement took 6 months from demand letter to payment. 6 months of uncertainty, but also 6 months of documentation, learning, growing, understanding how legal processes work. That knowledge transferred. I never spoke to my former manager again after I left. No exit interview confrontation, no final words, just professional separation. That was appropriate. The legal process had said everything that needed saying. $47,000 is invested now, growing quietly. It represents more than money. It represents the value of knowing your rights and being willing to enforce them. My contract at the new company has a dispute resolution clause, mediation required before litigation. I appreciate that. It shows they're willing to work things out rather than fight by default.
I still review my contracts annually,